think highly relevant, and particularly also for you in the context of the ALN Academy, are questions around what the EPA means in terms of the rule of law, governance, and transparency obligations for both countries, not just for Kenya, because I think that both countries, of course, have that obligation. The agreement does provide throughout scattered references to obligations that require that the countries adhere to the rule of law, and that there be transparency in the publication of regulations and rulings, and provides as an objective underpinning the policy of both countries with respect to the obligations under the EPA requirement of good governance. But the EPA is a little bit different from some of the agreements that we have started to see, particularly in the case of the US. And those agreements are often called WTO plus or WTO beyond agreements. And what that means is that originally WTO or trade agreements related just to trade and nothing else. They didn't really bother themselves with mentioning these objectives around governance and transparency and so forth. But that has started to change, and we can see a particularly marked difference in the agreements from around the early 2000s, and normally driven by the US, where entire sections in these FTAs are dedicated to providing for anti-corruption measures and requirements around the rule of law. So for example, if you look at the US-Mexico-Canada agreement, you will see that, again, there's a lot of text that is dedicated to ensuring that there are measures implemented around anti-corruption. It relates to sanctions relating to corruption, whether criminal or non-criminal. And there are very specific transparency requirements. And in the negotiating objectives of the US with regards to the US-Kenya trade agreement that is under negotiation, there are also these references, and they allude to making these requirements quite central to the agreement. That isn't the case in the EPA. Again, of course, these principles underpin the agreement, but there aren't entire sections that just relate to that. And that is one of the issues that tangentially was brought up by the House of Lords when they were reviewing the draft text of the EPA. And that is, as I mentioned earlier, that, for example, even though Kenya has huge issues with public procurement and corruption, in fact, is one of the fastest growing economic crimes in the country, corruption in procurement, that the agreement provides that the countries have 5 full years to negotiate what the obligations should be on transparency. So until those negotiations are concluded, there aren't any specific provisions that require either country to be transparent about how they go about public procurement. We'll see how things develop. Obviously, a strong rule-based system is more likely to allow the countries to leverage the benefits of an agreement of this type. And it also makes investment in a country more predictable for potential investors. So it is very important for countries like Kenya to try and adhere to the rule of law and to good governance and to transparency to the extent possible if it really wants to leverage these trade agreements.